To the governors and attorneys general of the several states, I write to you concerning an issue of increasing constitutional importance: the relationship between federal immigration enforcement operations and the enduring protections guaranteed under the Constitution of the United States, especially the Fourth Amendment's protection of the people in their persons against unreasonable searches and seizures. This correspondence is not intended to oppose lawful immigration enforcement, but rather to encourage a more organized, transparent, and mutually respectful constitutional framework through which federal enforcement activities may operate in harmony with state responsibilities and the enduring human rights protections guaranteed under the Constitution of the United States. This letter is not written in opposition to lawful federal authority, nor as an argument against the legitimate enforcement of immigration law. Rather, it is written in recognition that all exercises of governmental power, federal, state, or local, remain subordinate to the Constitution itself. Recent federal enforcement actions conducted within several states have raised significant public concern regarding transparency, procedural safeguards, operational accountability, and the distinction between judicially authorized warrants and administrative directives issued internally by federal agencies. Regardless of political position, these questions deserve sober constitutional consideration. The states of the Union possess not only powers, but responsibilities. Among these is the duty to preserve public order, protect civil liberties, and ensure that the people within their jurisdictions remain secure in their persons under the guarantees of the Bill of Rights. In light of these concerns, I respectfully encourage the several states to consider the following principles. 1. That all large-scale federal enforcement operations occurring within a state should include clear identification of the responsible federal authority and operational chain of command. 2. That distinctions between judicial warrants issued by neutral courts and administrative warrants issued internally by agencies be made clear to state officials and to the public. 3. That state governments establish transparent review procedures for allegations involving mistaken detention, unlawful seizure, excessive force, or denial of due process. 4. That cooperation between state and federal authorities remain grounded in constitutional standards rather than political expediency. 5. That all persons, regardless of citizenship status, retain fundamental constitutional protections against unreasonable seizure and deprivation of liberty without due process of law. The question before the nation is not merely one of immigration policy. It is a deeper constitutional question. What procedural and evidentiary standards must always precede the physical seizure of a human being by the government? The answer to that question will shape not only immigration enforcement, but the future balance between governmental power and constitutional liberty itself. The Bill of Rights was established not for moments of ease, but precisely for moments in which fear, urgency, or political conflict might tempt governments to bypass restraint. The enduring strength of the Republic depends upon the continued supremacy of constitutional principle over temporary passions and administrative convenience. I respectfully urge the governors and attorneys general of the states to approach these matters with clarity, restraint, courage, and unwavering fidelity to the Constitution. Respectfully,